our next session, we will slightly change topic and instead dig into sustainability. And for this subject, we are so lucky to have with us Kristiina Kouros, Doctor of Laws, KPMG Nordics, who, among other things, have worked for many years with human rights. Kristiina will focus on what it is that companies should prepare for the coming corporate sustainability due diligence directive. So, Kristiina, please.
Thank you, Ulrich, and thank you for Antti and Erik for the excellent presentations on the whistleblowing. So, Corporate Sustainability Due Diligence Directive, as Erik already mentioned, is not a finished product in Norway yet. It is in making, and I'm trying to see, I cannot move my slides at the moment, so let's, I continue speaking while we'll figure this out. So, or maybe my apologies. Here we go. It was my mistake, as usually with technology. In very short words, CSDDD or CS3D, however you like to abbreviate the name, proposes mandatory human rights and environmental due diligence. Human rights due diligence is no way a new concept. It's been around for somewhat over 10 years, but it has been voluntary. And what does human rights due diligence mean, or due diligence in general? It is this process. It is to identify, prevent, or mitigate and ultimately terminate adverse impacts on corporate activities on human rights and the environment. It is in making. The Commission has given the proposal in February, and there have been some national parliaments' opinions posted on the Commission website. Haven't checked in the last 2 weeks, but adoption could be expected maybe 2026 or 2027. I know that there have been some people who have said that this will not come to an end. It will never be adopted. I don't have an opinion on that. I'm not well informed enough whether that would be a possibility at all. But basically, the directive lays down rules on corporate due diligence obligations, directors' duties, civil liability, and protection of persons reporting breaches. That in a nutshell. Why? Now, what is the background? It's the legal fragmentation, what is going on in Europe regarding corporate sustainability. There are already countries that have passed their own laws regarding the issue, and some big corporations, for example, are of the opinion that they would like to level the playing field, and politicians are of the opinion that it's not a good idea to have well over 20 different types of legislations on the sustainability matters, that rather have one on the EU level. So instead of fragmented legislation, to have an EU level legislation. Well, who would fall under the scope of this directive? The current proposal covers about 13,000 EU companies and 4,000 non-EU companies. There are two groups of both EU limited liability companies and then non-EU limited liability companies. This is rather detailed description here. Than for the sake of time, I will not go into reading the details of this, but generally this would apply to larger companies with over 500 employees, and in some specific high-risk sectors that a requirement for the company size and turnover would be somewhat lower. Micro companies and SMEs would not be directly in the scope, but they would be indirectly affected as a result of the actions taken by the larger companies, because since they have to report on their corporate sustainability, it kind of trickles down to the smaller ones as well. Entire value chain would be covered. So upstream and downstream, besides own operations, indirect suppliers, direct suppliers, and then downstream customers and product disposal. So it is extensive, as Erik already mentioned. Obligations that are expected are aligned with existing standards, though, I would say. Substantive requirements are in the annex of the proposal, and they define adverse effects as a violation of rights and prohibitions laid down in international human rights conventions and environmental conventions. As for the due diligence process requirements for human rights, it is rather clear that the most important, the paramount document is the United Nations Guiding Principles on Business and Human Rights. And then the proposal refers to OECD guidelines for multinational enterprises and the OECD due diligence guidance for responsible business conducts. Substantive requirements were quickly mentioned in the last slides, but in the annex, it mentions 21 violations of rights and prohibitions included in international human rights conventions and treaties. 22 different international human rights conventions are referenced. I've not really done a calculation myself that would the 22 conventions include more than 21 violations. I kind of think that they could include more than that, depending on how you classify different violations. And then in the annex, there are specifically 12 violations of internationally recognized objectives and prohibitions included in the environmental conventions. In addition, Group 1 companies shall adopt a plan to ensure that business model and strategy are compatible with the limiting of global warming to 1.5 Celsius in line with the Paris Agreement. So due diligence process requirements. Due diligence process, like I said, is a well-known concept since 2011 when the UNGPs were adopted, endorsed by the United Nations Human Rights Council. There has been, and many companies have adopted this process of committing and having policies for human rights due diligence, to do impact, risk and impact assessments, to prevent and mitigate, to seize the actual adverse impacts, to have complaints procedures or grievance mechanisms, to monitor the effectiveness, and to communicate. And in case of an actual adverse impacts, to remedy the violation. So that is the process that the companies would be, well, let's say that they are expected to have the process already, obviously, but then they would be required to have it. Further, there are member states would have to lay down rules on sanctions applicable to infringements that ensure that companies are liable for damages if they fail to comply with the obligations to prevent and remedy adverse impacts. There would be supervisory authorities. Each member state would designate an authority with powers at least to order the cessation of infringements, to impose pecuniary sanctions, and to adopt interim measures to avoid the risk of severe and irreparable harm. There are contractual cascading issues. Companies shall bind their business partners to comply with human rights and environmental rights. And to provide guidance and support, the Commission would adopt guidance about voluntary model contract clauses. Coming to the end and highlighting the impact on directors' duties, it is good to note that not taking the specific consideration into account when fulfilling the duty to act in the best interest of the company will have to qualify as a breach of directors' duties under the laws of the member states. So this is also very important to prepare for. So what to prepare for and how to do it? I mean, I would say for a company, if I was a sustainability manager, I would suspect that you would already be familiar with the UN Guiding Principles on Business and Human Rights and the OECD guidance. If not, start reading these 3 documents. If you are and you are already applying, check and recheck and improve your process, because as we know, the human rights due diligence processes haven't been of that great of a quality according to various studies that have been conducted on national and international level. Then, and if there is no due diligence process for either or the human rights or the environment, then roll up the sleeves and start building one. It is not a quick exercise, so it's anyhow good to do it. Start doing it and get expert help to get there faster and with better quality. Those would be my 3 points of advice. And that's it for my part. I'm happy to take some questions if there is there from audience. Thank you.
Oh, thank you very much, Kristiina. I have one, because now we have seen some national law in different countries in Europe. How much can they be used as guidelines for people sitting elsewhere than these countries when it comes to preparing for this?
Do you mean countries outside EU?
No, I guess we have in Norway and Germany and France who have made some national laws already in this area. Is that something that you can already now use as guidelines, or do they differ a lot?
Yeah, sure. I would say that yes, but I have to say that I don't know the nitty-gritty details of the national legislation. So there are differences, unlike the UK Modern Slavery Act, which was already adopted first. I don't remember now the year, but it was first one of the sort of before Brexit, obviously, that had a more narrow take on the issues. And to my understanding, the latest one of these, the Norwegian Transparency Act, would be the one that would be maybe closest to this proposal. But I would say that there is plenty of guidance around the United Nations Guiding Principles on Business and Human Rights. United Nations has produced it. There is the working group following the implementation of the guidance, and there are many of the large global companies have implemented that for many years.
Thank you very much, Kristiina. for talking about this this subject and this area. I think it's something that we are all looking forward to follow in the years to come. So thank you a lot.
Yeah, thank you. And maybe just a final thing that I would like to add, that even if this proposal doesn't go through, the Corporate Sustainability Reporting Directive and the EU Taxonomy Minimum Safeguards, they are also referring to the due diligence process. So no need to wait for this proposal to start working on the due diligence. Thank you.